Yeah,
So thanks a lot, Gabby, for doing this interview with me 2 days before your Supreme Court appearance. How are you feeling right now?
I'm feeling quite nervous. I have been to many courts before, but I have not been to the Supreme Court of Canada before, and it is it can be as many as 9 judges, which is 3 times the usual quantity on a court of appeal, and they may be all grilling you if there is a subtle point that they all want to understand. So I'm a bit nervous. I think I prepare to the best of my abilities, as I would do for an exam. Uh, but whether it is enough for the Supreme Court of Canada, that is yet to be seen.
Right. So before you start the interview, you actually mentioned you have some special preparations you have to do tomorrow, Tuesday, 1 day before the court. So what are you going to do before you go to the Supreme Court tomorrow morning?
Well, tomorrow morning, I think I will not have much time to prepare because I will be just getting up and heading to teach and then heading to the airport.
Right. That's
Uh,
what I mean. You're going to go to teach first,
right,
teach a
right.
math class, and then uh, go to your math building, right, and take a cab to
Yeah.
the.
Well, certainly, the fact that I'm teaching twice a week this term helps in the sense of keeping my public speech skills up to date and keeping my articulation and my speech somewhat up to date. But appearing before a court is not like teaching, although certainly I think many faculty would be very happy to have as attentive students as judges tend to be. But it is, let's face it, it's not like teaching. They are not your students. We are before the top court of the country, and you are a little citizen there asking the courts to rule in a particular way, the way that you would like them to rule. So it is not a place where you want to be professorial.
Right,
It,
the justice don't like you to lecture them,
no, no,
especially you are not a lawyer. You're not a trained lawyer, I understand.
you are not there to lecture the court. You are there to argue, to please, to explain why you think that the law works the way that you argue that it should work. And the judges are there to ask you very tough questions and curveballs that get tossed at you. And in some sense, they are watching you how well you can answer the question. They will likely. It's a bit like you know if you really insist on an academic type of comparison, it will be something like a PhD defense. You file your dissertation, the committee has reviewed it, you may have some external opponent who has questions, and the committee then, after you present or even during your talk, your presentation, they will have questions for you. They will ask you at the academic defense on page 105 in theorem 2, you are saying something, I don't know why this is true, please explain it to me. Judges feel very much like the same. They have lots of experience in the law, and you in the Supreme Court you have 9 times tremendous amount of experience. So people who have been on the bench for decades, each of them quite often. And so when you multiply it by 9, you have an amazing experience, judicial experience and legal experience on the bench. But the same way as a referee in a math paper can say, I don't know how you get from A to B here, please explain, they may ask you the same kind of questions. So there can be different types of questions that seek to maybe convince other judges that your theory is wrong, or questions that are asked to help you to present your case better. That could be friendly fire in some cases, or basically could be very well a strong pushback on the ideas that you are presenting. Tell me, why do you think the law should be this way, and why shouldn't be something else?
Right. So this case, can you explain briefly in a sentence or two? It's you against Delta, right? In
It's
fact,
more. It's more.
especially you're not appealing the decision. Can you briefly 2 sentence explain, talk
So
about the case, and then like what's your role in here?
So the issue here is who can complain about discrimination against large passengers by Delta? Does the complainant have to be large or in some way personally affected by the complaint in order to make such a preventive complaint? And the Canadian Transportation Agency tossed out this complaint because they said, yes, you have to be personally affected if you want to complain. Now, that would make sense if you wanted money or something about events that happened in the past. But when you're talking about something that may be happening in future, preventive complaints, this makes absolutely no sense. Just think about it. If you have a car driving down 160 kilometers per hour on the highway, who can complain about it? Do you have to be hit by it before you can call 911?
Do you have to die first, or do you have to see a little kid die, or can you call 911 like you?
And obviously the answer is no. The purpose of complaints of this nature is to prevent injury to the public. That's the whole purpose of regulatory law. That's why we have food safety rules, and the Canadian Food Inspection Agency can order foods off the shelf when they are spoiled before somebody gets injured. That's why the police can give you a fine and possibly suspend or revoke your license if you are speeding and it's second or third time that you are speeding. And this is why you have Ontario Securities Commission to intervene if somebody is, for example, doing insiders trading. If possible at all, they want to step in before the public at large is harmed.
Right. So I don't want you to give away...
So what happened here was that the Canadian Transportation Agency tossed out the complaint. Then the Federal Court of Appeal agreed with me that the decision was unreasonable to dismiss the complaint and told the agency to look at the complaint and decide whether or not to deal with it on a basis other than the law of standing, which is the notion of whether you are personally affected. And now Delta Airlines is appealing that ruling of the Federal Court of Appeal, which sided with me.
Right. So that's the key. You're not appealing a decision. It is them appealing the decision. So I had a quick look, actually not look, I can say reading it, but I scanned your filing, which is 50 pages in the PDF, and they have like a 15 or 14 pages reply. So I don't want to go just compare page number and say the arguments and whatnot. But
I must correct you that they also filed about 40 pages of arguments. If you look at the website. So what happened was this, and it may not be clear from the list of documents.
Okay, so
first, Delta filed a 40-page document, then I filed a 40-page document, then the Amicus Curiae filed a 33-page document that someone appointed by the court to give advice to the court, and then...
That is not a party, or is the court asking for someone else? Advice?
Yes, someone has experienced lawyer's input too, because I'm self-represented. So the court would like to make sure when you have a self-represented party that perspective is also clearly explained and represented by a lawyer, even though the party may be proceeding on their own.
Is the third party here, are they hired by the court? I mean, this is new
to me. Yes, it basically is the Attorney General paying for it.
What's that?
It is the Attorney General.
Oh, okay, the government of Canada.
Yes, but the court ordered. So it was the Amicus Curiae was appointed by the order of the Chief Justice of Canada.
Oh, I see. Right. So I don't want you to give away any secrets that you're going to use on Wednesday.
Just to give you a context. So this were the submissions. Then there are 4 more interveners. The Canadian Transportation Agency, the International Transport Association, the Council of Canadians with Disabilities, and the Ontario Attorney General of Ontario. So so basically, in terms of they filed each of them 10 pages, and then Delta and I, each of us filed 10 more pages of reply to those.
I see. Right.
That's what we were saying.
A lot of stuff.
So I don't think that this case depends or should depend on how many submissions each of the parties were making. It's really about the quality of the arguments.
Right. So the Council for Disability, that is definitely with you on this case. Are they all? The rest are against you, or some are with you and some are against?
The Attorney General of Ontario is actually very supportive of my position, with the caveat that they say, and I think that their position is very reasonable, that when the statute of a tribunal or an administrative body, this prescribes who can and who cannot make a complaint, and obviously that will prevail over any other matter. But they say when there is no such provision, when the statute is silent, in that case, it is irrelevant who is making the complaint. Like in the case of the 160-kilometer
speeder and the passerby, like, hey, it could hit my kid or hit me. Let me call the police.
And I mean, it doesn't even have to hit you. So suppose that you are just inside a big, tall building. You are at no risk whatsoever.
I see.
But the question is, whom are we trying to protect? Is the police is not your private police force. And generally, the purpose of regulatory law is to protect public or societal interests, not private individual interests. The shift of paradigm, the shift of way of thinking from dealing with matters after people are injured and individual claims to preventing injury. There is an old saying that 1 ounce of prevention is worth 1 pound of cure.
Right.
It is very true here.
Yeah. So roughly, how much time have you put into preparing for this case in the Supreme Court? Yeah, from appeal, and you thought you got it, but then they appeal. How much time?
So first there was the leave to appeal process, that permission to appeal. That I spent about 1 week of work, more or less, to do that. And then once we got to the appeal stage, preparing my factum, it was a 2 months process. Now I would not want to suggest that every day I got up and I was working only on this. But in terms of if you add up the bits, I would say it was something to the tune of a month of work to actually put the pieces together the way I want, and then the interventions, and then preparing for my oral arguments, and preparing the so-called condensed book, which contains just those portions of the authorities in the record that you want to cite to the courts. Just yesterday we finished printing and binding 30 copies.
Wow.
So that has been, just printing and binding took a whole day, never mind preparation. So we're talking here about many weeks of work after the factums are ready to prepare for the best show at the court, the best possible way of delivering the information. And the main thing is, because the purpose of a hearing is for the courts to ask you questions normally. Right. What you want to be is to be ready for any and every possible question. Whatever curveball they may be tossing at you, you want to have a ready, prepackaged answer. And that is the real challenge.
Right. So I know you have to pack, so let me wrap up with a few questions. So have you been to the Supreme Court as a tourist, or, I mean, this is your first case at the Supreme Court, so this is your first appearance walking in. How are you going to feel? Do you know how you're going to feel when you walked in?
I've never been to the Supreme Court before.
Not even as a tourist. So this time, time you walked in,
nor as a party. It is very. I'm quite nervous. Normally on the day of the hearing, getting up in the morning is not an easy experience. You kind of start wondering, why am I doing all this? Why am I not just worrying about watching nice movies and going for long walks so the days leading up to a court hearing are very tough on me. A couple of days ago actually was having some kind of almost like a nightmare, imagining that I'm there in the courtroom and somehow not really being able to deliver what I want to say. It's very stressful. It's really very stressful, and one of the reasons that someone like me has to do it, because if nobody is willing to do it, then things are not going to change.
Right. So when you are arguing the case in the Supreme Court, how long is it going to take? And are you going to be taking up part or portion of the presentation, or basically you'll be standing up a lot and getting ready to answer questions as the other sides are presenting? And have you been watching a lot of CPAC on Supreme Court presentations?
Sure. So the way it happens in courts, you don't have more than one person presenting at the same time. So first, Delta is going to present their case. Then two of the interveners are going to present who are supporting the other's position. I suspect then the court is going to take a recess. We don't know. That's usually the practice. Judges also like their coffees. They're humans too. And then after the recess, I expect that I will be presenting for 40 minutes. Then for 20 minutes, the Amicus Curiae, the court-appointed lawyer who was there to argue, to help the court give advice. And then 5 more minutes, two of the remaining interveners who support my position. And then for 5 minutes, his reply for Delta. And at that point, I expect that there are two things that can happen at that point. Either the court is going to say, we are going to reserve our judgment and the court is adjourned, or the Chief Justice may say that the court will now retire, which means that they are going just to go back in a back room and discuss the case and with the possibility of rendering a judgment on the spot.
Oh, really? Wow.
I've seen that happen in one case that I watched. In this case, I would be surprised if they were issuing a judgment on the spot with having all factors considered. It's a too complicated question. My instinct is that the court is very interested in the broader question of administrative law here and may want to address that one way or another. I'm not sure which way, but that's the part that makes me nervous. But they probably want to address the substantive question of who actually can complain to an administrative body, to a regulatory body. And this is, in many ways, this is where the difference is going to be, because you can have bodies like the Social Security Tribunal, which gives you individual remedies, and you have bodies like the Canadian Transportation Agency, which is a kind of enforcement body, regulatory body type of body. It's not, you cannot have it's not like a one-size-fits-all. The administrative bodies differ in their scope and abilities and powers so much that's what the main problem here, and certainly that is where what my line of argument has been and will be, and that's what the Federal Court of Appeal recognized correctly, that what we are dealing here with is, a cat which is claiming to be a lion. That's the Canadian Transportation Agency. They have been trying to pretend that they are a court.
You're not a fan of the CCA.
No, I'm not. They have been pretending to be a court, and that's where the Federal Court of Appeal said, no, you're not a court. You're not part of the judiciary. You're part of the executive. And that has a wealth of implications.
Right. So if I hear you right, 40 minutes you talk, and then, well, obviously, they will talk before, but they got 5 minutes, and do you have 5 more minutes at the end to wrap? So then you have four minutes.
The appellant gets the final right to reply. Now, I haven't seen it happen, but it's theoretically possible. It has happened in some cases that if they pull out something from their hat, something unexpected about in their reply, the court may actually call me again to provide a response to that. I have rarely heard about it. I've seen it happen in the Federal Court of Appeal, especially with my replies. That's one of my weaknesses, that I'm not good with giving good reply. That's an area where I would like to develop my skills. Because often I've been criticized by the court before of giving a reply which is more than a reply. And so if that would happen in the Supreme Court, the court may give them a leeway, but if they raise something brand new, they may say, well, counsel, we may want to hear what Dr. Lukacs has to say on this point. Not very unlikely. They usually can follow the schedule, but anything can happen. So it's not like I give my presentation and then go home.
Well, then you can fall asleep. They may ask you something.
Yeah, the idea is to keep taking notes, to keep listening very attentively to what they are saying, what they are doing, and push back. So there's one more thing, in which case this is unique. This is the first time I'm a respondent. I'm usually the appellant. I'm usually the one who wants to judge something to happen.
You're usually the underdog in front of the court, and then you try to argue something.
Yeah. And so this time I will be pushing back against changing something which the federal court already substantially got correctly. There is one minor point on which there was some confusion, but they got the essential points correctly. We are dealing here with preventive powers. It is not a court. It would not make sense to deal with preventive powers if you had to actually wait until somebody is injured, is hit, is harmed before those powers could be used. And if the purpose is to prevent harm indeed, as which is common ground, then it makes no sense to say, okay, just because you are less likely to be hit by the car than someone else, then I'm not going to take the complaint from you. Because it doesn't matter who the source of information is. The Canadian Transportation Agency just recently commenced an investigation based on something which is only a media report. And there was no complaint,
Oh, I see.
nothing. In the Air Transat case, there are lots of media reports.
Right,
And
right.
they actually acted merely on a base media report without any concrete complaints.
Right, yeah, they did it immediately, and there isn't the formal process take long. So let
That's
me
right.
wrap up this interview by going to one of my previous interview. You have done this for years, but at least when I first interviewed, it's already 2013 August, so more than 4 years
4 years,
ago. So
yes.
how does this long process, like that was the case where you got bumped Air Canada passengers 200, 400, or $800 compensation. That was like awesome. Did in fact benefit all the Canadians. How does this whole process feel like for you? Like fighting for different passengers in Canada. And this process gets you to the Supreme Court. You cannot go higher than the highest court of the land. How does it feel like all these years and hours of work?
Well, on the one hand, I wish someone else who does this full time and gets paid for it would be doing it, and I wouldn't have to do it myself. I would rather spend that time with my students for doing mathematics if there was somebody else doing it. The problem is that lawyers cannot afford doing many of those cases because there's no big money in it. It's not just that so in class actions, you usually can have class actions where you at least have a big financial impact. Here it has a very significant impact on people who are being discriminated, which is horrible. But at the same time, you cannot easily translate this to money. The other aspect is that what we see here with airlines, which is a broader phenomenon, that airlines disregard the law. Airlines think that they can do whatever they want because anyway the Canadian Transportation Agency is not going to protect passengers, so what can the passenger do? They would just go home and move on. That is the mentality that I don't accept, and I would love to see change. In my view, a bargain is a bargain. Once the airline agrees to come, for example, in this case, Delta, if Delta wants to do business in Canada, they have to respect the Canadian law and the Canadian values. And if they don't feel like doing business here, they can go doing business elsewhere. We don't want someone to come here and bring here values in their business culture which we don't accept. So we are not going to accept airlines that put women in the back of the plane, or that put black people in the back of the plane, or that prevent people who are based on their religion or nationality from boarding the plane. These are not acceptable acts in Canada, and we don't want airlines to do that in Canada. It's a broader issue. So, airlines. I view airlines as embody many of the problems that consumers face in their dealings with large corporations. And large corporations feel, and may rightly feel so, that they own the system. And that's not right. That may be a short-term profit, but in the long run, it actually destroys the very sensitive system of checks and balances that actually make capitalism work, which is free market, free competition, when I'm talking about free competition, I don't mean freedom to rip off people, but rather freedom to compete based on well-established ground level standards that everybody has to meet. That is when in general, if you allow in any area companies to engage in race to the bottom, which is what you see now with airlines, then it is not going to result in a positive type of sustainable economic development. You can have cash grabs because the companies will do less for the same money possibly. But for a sustainable, profitable airline sector, you would want airlines that invest in better and better technologies, more and more fuel-efficient airplanes, better ways of boarding aircraft, better ways of scheduling things. So development of technology is the way to go and not just cutting services.
Right. So since you're flying off to Ottawa tomorrow, Tuesday, and then leaving Ottawa on Wednesday, you got two chances of accidentally running into the Minister of Transport, Marc Garneau. What if you got trapped in the elevator, airport elevator with him for 30 seconds? What are you going to tell him in 30 seconds?
I would probably tell him that he should not trust people at the Canadian Transportation Agency and at his own ministry. Looking at Bill C-49, it's quite clear that the people who are...
rights bill?
Sorry?
The bill, as per
Yeah.
passenger rights bill, right?
Well, it is the air passenger bill without rights.
Without rights.
So when you look at that, it becomes clear that Minister Garneau is being given misleading information by his staff, and that's very unfortunate because it looks like he's very much convinced that what he's doing is going to improve the experience of Canadians. On reality, I'm concerned that it will do, at least in the short term, only to enshrine the status quo.
So let me take off my independent reporter hat for a moment and speak as a flying Canadian who also has friends that has problem with Air Canada's and other airlines. I wish you the best of luck, and I hope to talk to you after your appearance at the Supreme Court, and hopefully you can get me a photo. I know you don't take selfies, but good luck, and talk to you after your case.
Thank you very much.